probably have a view. I don't have a view.
Okay, let's get started with the third and final panel of our conference, which will be on financing emerging companies and startups. My name's Jim Park. I'm the faculty director of the Lowell Milken Institute. I teach securities regulation here at UCLA, and I remember the first 5 or so years of teaching the class, I would sometimes warn students this is a tough class, it's a little bit dry, and so you really should only take it if you're really, geared for a very tough experience. But something happened over the last 3 or 4 years, and there's so many interesting issues now in securities regulation, so that it's become much easier to teach the class. So many, issues that are coming up, and I think it's a very exciting time to be practicing in this particular area. And so I think that just the emergence of a set of emerging companies here in Los Angeles has been very exciting. Seeing Snap do a very successful IPO, I think will be very good for the Los Angeles startup community. And there's a lot of difficult questions that are coming up about SEC regulation and its scope. And I think that a lot of the pressure is coming from these private companies and their needs with respect to the regulations. So we have a wonderful panel today, a great set of experts. Lona Nallengara is a partner at Shearman and Sterling. He also worked extensively on the SEC's regulations implementing the Jobs Act. Nick Hobson is a partner at Cooley, where he focuses on advising startup and emerging companies. And I'm also proud to say he's a graduate of UCLA School of Law. We're always very happy to see our alums come back and succeed and so forth and become experts very soon after they graduate. So it's especially good to have Nick. Adam Ettinger is a partner at Sheppard, Mullin, Richter, and Hampton. He's one of the leading experts on blockchain technology and legal issues involving that very exciting new field. We also had a fourth panelist, Pippa Bond from Proskauer Rose, who unfortunately got caught up in a client matter, so unfortunately was not able to attend. So I thought I would start out by directing a question to Lona. You worked at the SEC during the period when the SEC was promulgating various regulations implementing the Jobs Act, and I was just wondering first what sorts of insights you might be able to give us with respect to the various policy considerations the SEC considered in coming up with those regulations, and also from your view as a practitioner now, what can you tell us about whether you think those regulations are working and how effective have they been?
Thank you, and thanks for having me. It's great to be here. So the question you asked was what was the SEC thinking when they wrote the rules implementing the Jobs Act, and what has the impact been? So most of the rules implementing the Jobs Act I was involved with, and I'll accept responsibility for there's probably no typos, but beyond that, I can't promise it's much better than that. Largely because keep in mind the Jobs Act was a piece of congressional legislation. It was a mandate from Congress that directed the SEC in some cases to implement pretty specific rules. And the framework within the SEC, the staff of the commission had to write those rules was very narrow. So when you think about whether crowdfunding or Reg A Plus is a practical exemption to raise capital, to turn your eyes to the implementing legislation and see where the framework was developed from, and then also there's a lot of skepticism with both the commissioners and the staff on whether something like crowdfunding or something like a rejuvenated Reg A was going to be really that thing that was going to raise capital for smaller companies. Also, there's a sort of another thing to keep in mind that the Jobs Act, lots of commentators after it was enacted, tried to characterize it as some brilliant piece of legislation from Congress, and brilliant and Congress all in the same sentence seems odd to begin with. So you should have questioned that sort of reference. But the Jobs Act was generated in 15 or 20 different bills that sort of percolated along independently of each other, and then only within the final six or 8 weeks did they all get sort of mushed together. So to think about the Jobs Act as some sort of, I've heard references like it's the life cycle of a developing company from crowdfunding to Reg A Plus to the on-ramp in Title I. It's just nonsensical, right? It doesn't make any sense, because you have, on one end, you have this on-ramp to be an IPO company, and the other end you have the 12G thresholds being increased to 2,000 holders. So if you're trying to encourage IPOs with Title I, but at the same time you're saying you don't have to go public if you have now 2,000 holders, there is a little bit of a disconnect between the themes behind it. So keep in mind, don't look at the Jobs Act as some kind of piece of legislation that was designed to address holistically market structure issues and capital formation issues and regulatory issues related to public companies. And then also, don't think about the Jobs Act as being done, right? I think Congress recognizes there are gaps in the legislative mandates that were given, and if you look at the bills that are percolating now in Congress, they are revisiting crowdfunding, they're revisiting Reg A Plus. So think about as you look at those rules, think about what doesn't work, and don't keep that to yourself. Tell the SEC, tell industry groups, because there is active interest in trying to fix the busts in both crowdfunding and Reg A Plus.
Thanks, Lona. Adam, you've developed a thriving practice advising innovative companies. From your perspective as a practitioner, what would you change about SEC regulations? Has the Jobs Act been particularly helpful? Has the SEC been particularly helpful with respect to fostering innovation in financing?
I think it was definitely a step in the right direction. I mean, again, it was a congressional mandate. I think that there was, both in large law firms and probably with the SEC, skepticism is a kind word when it comes to crowdfunding. There was a lot of feeling that it wasn't crowdfunding and making equity available to the masses that caused all the problems in the 20s, and that's why we have all these securities acts and regulations. So you had a difference of opinion. People, more like me, who come from a Silicon Valley background, who have seen what entrepreneurship can do for technology, what it can do in healthcare, what it can do for a country and GDP, and willing sort of to risk the expansion of crowdfunding in order to get to those aims and goals. And then people who thought that it would just be, the more that you open up crowdfunding, the more you're just going to have wholesale fraud, mostly because of the ineptitude of teams and the people actually trying to sell their equity. I think you kind of saw that in the implementation of regulation crowdfunding and some of the other stuff where it's went with the congressional mandate, but it was by no means sort of a wholesale embrace of let's just embrace the risk that's going to happen. The limitations and the requirements are quite constraining for an entrepreneur. Where you have a $500,000 cap, you have a $1 million cap. That might be great if you're doing web development, in the Philippines or some other places. It's very hard to do, really build a good technology company with those kinds of limits, and considering all the effort that's going to go into the raising. Reg A Plus was so interesting because it sort of came as this thing that we had to look at twice because it looked too good to be true, and I think it's good. It's a very good thing. It raises limits. It sort of prepares companies, I feel, for an IPO on-ramp, because it is very much, in terms of compliance and filings and disclosures, sort of a mini IPO. I don't know if my co-panelists would agree, but it's a lot of that sort of feeling. And the SEC understands that its mandate is there to really foster U.S. entrepreneurship and make sure that teams stay in the country and so forth. The challenge, at the same time, what happened, I don't think the SEC expected it. Well, nobody expected it. It's like nobody expects the Spanish Inquisition. Was that a bunch of people said, hey, wait a second, I now can use new technology, blockchain technology, to offer either cryptocurrency or investment contracts or equity pieces, and I can do it, at least from a technological standpoint, for minimal expense, with minimal effort, and transborder. And one of the issues here is that, it's terribly easy for a 27-year-old to form shop, right? And we don't want to see the entrepreneurship leave the United States. I remember a client that I had in the 90s that I did a lot of internet infrastructure and what have you, that kind of entrepreneurship and those kind of ventures. And one was the leading American firewall company. And they just knew they were going to lose in the United States because at the time, if they tried to export strong cryptography, that was considered a munition, much like trying to export nuclear weapons and that kind of stuff, which made no sense. And luckily, the law, we were able to change those regulations just in time. Otherwise, they would have lost their competitive position. A lot of companies that are moving abroad in order to take advantage of other forms that are less regulated, we don't need them. A lot of them, it's sad to go. And so one of the challenges with the SEC is their general approach is not preemptive. It's, at least certainly in the space of token sales and ICOs, it's to sort of try and grab one example every once in a while and say, that's not what we think something else, and give different guidance. We've seen very instructive guidance because of a investigative report. It wasn't even an enforcement action against the Dow in July of last year. I believe it was July. And then on December 11th, a consent order with Munchie, which was wonderfully instructive and fantastic in terms of, even if you disagreed with the reasoning, at least giving the delineation of the reasoning that would help with some predictability. But still, you see that some regulatory bodies, whether it's Canada or the UK or Singapore, did this wonderful job of saying, here are these different examples of crowdfunding using tokens, using blockchain technology. This is what we consider problematic. This is what you need to register. This is fine. Whereas the SEC is much more, well, we just need to see the facts and circumstances when we take an enforcement action. which not being in litigation, I'd much rather, actually have a lot more guidance earlier on.
Lona, do you want to briefly respond to that? There does seem to be this tension between entrepreneurship and investor protection, and the possibility that if you regulate too much, firms will simply go offshore or to different jurisdictions. And I've always been curious as to where the income limits for the crowdfunding have come from, where there's almost a tug of war there between Congress and the SEC.
Absolutely, there is a disconnect, and I when I was there, and I saw it, and I see it now, that the idea of how the capital can get raised within the private markets at the investment level, that knowledge doesn't translate or permeate as quickly or as well to those writing the rules, or more importantly, writing the legislation. So, and what the challenge with crowdfunding, and even though Reg A Plus has been a success, it could have been better. There were certainly some things that I think that are being considered, like higher thresholds and providing easier listing mechanisms that would have been considered, but for the fact that the legislation didn't provide for the mandate. And the challenge is the way a bill gets written, right? You've got two parties, and they have wholly different perspectives, and when you try to get a piece of legislation passed, it ends up being a mush of stuff that ultimately doesn't work. And you saw earlier drafts of the crowdfunding, the ultimate bill, that were actually far more reasonable than what we have today. And what happens is that it gets into conference, and there's some 27-year-old who's sitting there who has like 15 people writing them from different sides of the aisle, and they end up taking whatever they think will work, and it ultimately doesn't. And not to say that the SEC is the best writer of rule, but having Congress write specific securities regulation, that doesn't make a lot of sense, right? Providing broad frameworks for, and that applies to any regulatory issue, providing broad frameworks for how the rules should be written, and then sending them off to write rules with a full notice and comment period where all of you can look at a draft and say, these 10 things don't work because no one's going to invest in the company if this is the way you're going to do it. That seems like a better way to write a rule than a bunch of people sitting in dark rooms in Washington and then sending it out.
Nick, I wanted to ask you a little bit about your practice advising emerging companies in Los Angeles. And in particular, I wanted to ask you to what extent are you advising companies about SEC regulation and the securities laws at a very early stage, which I understand many of the companies that Cooley might represent in Santa Monica are very much emerging. And so to what extent is SEC regulation relevant in your advice to them?
Sure. Yeah. I mean, I think with a lot of the recent regulations that have been implemented, it's raised a lot of questions. I mean, the entrepreneurs, they'll read about it, they'll hear about crowdfunding, they'll hear about being able to solicit, raise capital from unaccredited investors, and it sounds very appealing, right? If you're an entrepreneur, you just started your business, you're one of the first things you're trying to do is raise capital. And so, on paper, it sounds very appealing. Once we get into the details, it tends to narrow down the number of companies that it's really helpful for in practice. The really early ones, having to go through, that sort of mini IPO process isn't really practical from sort of a cost perspective. If they are planning to raise venture capital, a lot of the VCs still are a little hesitant about, the concept of a company with thousands of, small stockholders. And so there is a little bit of a concern that if you go down that path first, you're kind of closing off a separate path further down the line. So sort of to Lona's point, it's not really the life cycle. It's, you're going to sort of pick which avenue you're going to go down. So the vast majority of our clients are, still venture-backed doing, Reg D offerings. And, there are obviously cases where Reg A Plus makes sense. If you've got a company that's a little bit further along, generating some revenue, maybe not planning to be sort of a 10x venture capital target type of company, but needs to raise some additional capital in that sort of range of up to 50 million, and is willing to bear the costs of going through the audited financials and all of the process that's involved there. So we do have a lot of those conversations, but when we sort of give the pros and cons and the entrepreneurs make their decisions, it still seems that the vast majority of the time the best fit for them is really sticking with the traditional Reg D offering and going sort of with more institutional and accredited investors.
Just to follow up, the 506C is not really an option for your clients, or are there emerging companies that are using general solicitation? If either of you want to speak to that.
Yeah, again, I think it's something where it does fit for certain types of companies, particularly consumer-facing companies, where you want to reach a broader investor pool of investors that are maybe passionate about the product, that they might be both a consumer and an investor. But it's probably a little bit of the bias in our practice, just given that we are sort of Silicon Valley and Silicon Beach focused, and we tend to work with companies that are venture backed. That as the prior panels have said, there's such a pool of capital right now in the venture markets. I mean, it's over the last decade, the amount of capital invested by venture-backed or venture capital funds into startups has doubled. Last year I think it was $80+ billion, and so there's all this capital that needs to be deployed, and it tends to be the path of least resistance. Is to there's particularly here in LA, there's a lot of seed funds And so I think that's part of the reason why LA's been so successful over the last few years, is that initial round of capital is often the hardest round for early stage companies to raise. And so if you have a big pool locally of seed funds that can help those companies get off the ground, raise that first $1 million, then when they're looking to raise larger rounds and going up to Silicon Valley or elsewhere and talking to the larger VCs, they're doing so from a position of strength, rather than having to compete with every entrepreneur that has an idea coming straight out of college. So.
Got it. Just a quick follow-up, Lona. Does it surprise you that general solicitation is not being used, given what the SEC was thinking when it passed 506C?
I think so. What I've heard, what I hear, and what clients are saying is that the reasonable steps to verify is just not as easy as I thought it would be, and the examples in the rule weren't clear enough. But I think Nick is right. There's lots of capital available that you don't need to put an advertisement out. You don't need to put it in the paper. You don't need to put there was all the fears at the time of writing the rule that there would be billboard ads saying buy stock of this crappy company or something. It just obviously didn't happen. And I don't think companies are for the size of offerings that we see, we're not going to see someone put a newspaper ad or a radio ad. Maybe it's that I think someone mentioned in the last panel a brewery or something, but maybe it's that brewery at the in your neighborhood that's going to put a sign up in the window and say, if you want to own part of the beer you're drinking, you can talk to Gus at the end of the hall. Maybe that's what general solicitation works for, but I'm not sure. And then I think some larger funds are going to have are certainly going to be making use of it as well.
I mean, do we know what the numbers are for 506C in last year?
I saw some. It's about 10% of the 506 offering. That's what I saw.
Huge.
Okay.
I mean, I think that's. I mean,
Okay.
506 offering is a rather substantial amount. So 10%, I think, is a rather huge
I think 10%
amount.
of the number, the
sorry?
number of financing has been about 10%. Not
Oh,
the
the number
amount
of
raised.
actual
I don't think. Yeah.
I was going to say that I actually would find surprisingly successful. But even so, I mean, look. First of all, there's a lot of general solicitations that were just happening, right? And you couldn't actually say, well, I did a general solicitation, let me fix it. It just wasn't a great way to fix it. Part of it is, I always like the idea of a regulator saying, we're aware that there's a certain amount of, how shall we say, enthusiasm in finding investors. Here's a way to be compliant. That's always great. Then the second thing is, we have had many clients that embrace it for a whole bunch of reasons. One would be a platform that is offering, let's say, there's the real estate crowdfunding, frankly, has been very successful, especially when they're only appealing to a credit one. When they're appealing to accredited investors, it's kind of nice because the accredited investors know real estate, and the platform makes it a nice way to invest in real estate. But there's a general solicitation, which couldn't have been done before, nearly as easily. And we got these safe harbor provisions, which you're either going to be looking at a lot of tax returns, or you're going to get a letter from an accountant or a lawyer. And most of the time, we get the letters from the accountants and the lawyers. But the point is at least we had some bright line safe harbor rules for it, as opposed to, something that was vague and ambiguous about having a reasonable belief, which that would have been either a quagmire or a race to the bottom. So it's nice to have it there. It's great that it's been there, and I think it's been utilized. I don't think because it's still the idea of being limited to accredited investors, I wasn't expecting it to be this blowout new way of raising money.
A company can only sell securities, whether it's to private or public investors, if it's able to convey what the business is about and that the business is promising. I was wondering if the three of you could comment on your views of the lawyer in facilitating that particular process, and whether advising emerging companies, technology companies in particular, raises particular challenges with respect to crafting disclosures and conveying the company's story. Nick, would you mind starting out?
Sure. Yeah, I mean, I think the vast majority of our clients will put together a pretty high-level investor deck, 10 to 15 pages on what's the business, what's the team, what's the competitive landscape look like, how much are we raising, and then what are the use of proceeds, right? And that will go to, a handful of venture investors where, they're out there in the market. And then, once that, the purpose of that deck is really just to get a meeting, right? And get in front of the VCs. And then from there, it's, just direct interaction with the venture capital investors, until you get to the definitive agreements. And then it's, just the disclosures are just part of the purchase agreement, the reps and warranties, trigger disclosures. But for the vast majority of our clients, they're not doing a broad, outreach. It's pretty targeted to, we know that these investors are interested in this space. They have the capital to deploy. This is the stage they're interested in. And I think that's another reason why, so many companies are staying private longer now, is that there's, such a depth in terms of, institutional investors that, are able to convey to the companies the types of businesses that they're interested in, which helps, bring them together in a much more efficient manner.
So that they're able to convey that more just through just through conversation as opposed to formal disclosure. Is that what you're saying, or is there something like what would you demand as a disclosure if you are a private investor? What sorts of things do they want to see verified? What sort of things are in writing and so forth versus
Sure.
just kind of talking about what the business is about?
Yeah, I mean, once you get to that level of diligence, right, the investors are going to hire legal counsel to do the legal diligence. They're going to review all the contracts. They're going to, maybe hire accountants to review the financials. And then you're going to have to give reps and warranties as part of the transaction to certify that what you've presented is accurate, right? And so you'll have reps and warranties as to, your registered IP, as to your material contracts, that they're valid and binding, as to your financials, that they're accurate. There's no liabilities that have not been disclosed. So that's all done really through the documentation process. But you only get there, once the VCs have determined that they're excited about this business, which is really more, on the business side, the entrepreneurs being able to convey that they're the right people to take this idea and it'll be a big business.
I think it's been really surprising, how much private investment with venture capital happens based on a high-level deck. I guess I'm aging myself. There was a time when people prepared large business plans, and it was a big deal. And the joke was, the investor will read, the executive summary and then fly over to the bio page just to see, what the actual biographies are, and get a sense of team, and then maybe they'll dig into some other areas, and not that much. And you've spent months doing it, and you hired a consultant and whatever it is. So I think maybe the investors realized they could get enough diligence and get enough of an impression of whether or not they want to do the deal without even that. What you also don't see in the Silicon Valley model are private placement memorandums, which is an offering circular that's supposed to help assuage the fears of your students that there's not a 10b-5 problem where there's not a material misstatement or an omission that would make what was stated materially untrue. I know I got that slightly wrong. In any case, the point is that you're telling the investor everything that's correct, and that you're not missing things. You still see this obviously a lot in real estate deals. You see it in fundraising. You see it in many different areas. In Silicon Valley, it's almost, unless you're a venture capitalist trying to raise money for your fund from other investors, you just don't see them very often. And what's interesting about it is you don't see the kind of litigation that you would normally expect to see in other areas. So it's for whatever reason it seems to work in this environment, and I think part of it is the feeling, people have the need for speed. They need to be able to find that company, for everybody to be focused on product development, and to invest and to move on and try and find the next investment. And I think they see not being able to do that speedily being one of the greater risks.
The other what I see, I do a lot of work in biotech, is that there is some diligence, not legal diligence, not documentary diligence, but understanding the understanding that therapy or just understanding the science behind it. And so at the time that they're looking at the deck, someone's understanding the science, and so that's an important part. It's something that as a lawyer I can't help a lot with, but it has been an important component of the tire kicking that happens.
One of the themes of the conference has been that it's getting harder to be a public corporation. It's getting more expensive. And one of the reasons for this is that you need very stringent, very developed internal controls within the corporation. And I just wanted to ask you, we know, I think, at least from the prior panels, that many companies don't envision doing an IPO. They don't envision being that public corporation. But do they still, is there still a focus on developing internal controls to get through the venture capital financings? Is that something that you think about at an early stage? And if so, what sorts of controls do you think are important for emerging companies? What are investors demanding? Are they demanding anything at all? Or is it just they're going on sort of gut and the founders and their biographies? Nick, I don't know if you would want to try to take this one.
Yeah, I mean, at a certain stage, they're going to want to see audited financials. I'll give you one example. And then as part of the deal, they're going to negotiate, certain protections into the governing documents. As part of the board seat, there might be certain things that their specific director has to approve. Maybe that's the budget. Maybe it's expenditures above a certain threshold. Maybe it's hiring, employees with a salary above a certain threshold, any kind of material transactions. They might put in place committees, so maybe a compensation committee to, approve, the founders and other executives' compensation. Maybe an audit committee. So there's ways that they, work in the governance that they're comfortable with, and different VCs have different approaches, and it tends to ramp up as the companies get further along. Obviously, if it's a brand new startup, there are no financials, right? And so that's of limited benefit. But as the companies grow, you start to see them implementing, more processes. But these companies, they move quickly, right? And they're constantly pivoting and shifting. And so, and the VCs are investing in a lot of different companies. So there's only so much attention that they can give to any particular portfolio company. So it's just about putting in the processes that they feel comfortable with.
If I can just add to that, I was thinking about it as you were talking. So one of the reasons to stay private is to not have to deal with all the processes and controls and potential liability of being public, and so that your team, which is constantly trying to build and create new businesses with new clients, can run and do so well. It's one of the reasons to stay private, because there are these controls, and you do need a different class of financial management, a different class of legal management, and that said, there's some things that are affecting sort of compliance at an earlier stage. One is mainly privacy. If you're doing a business, certainly in the United States, you need more awareness of privacy and privacy controls and tracking of data and these sorts of things. If your GDPR is, a nice way to say it would be getting attention of companies at all stages. Scaring the bejesus would be the unnice way of saying it, because the bottom line is if you're doing business with European countries, the rigor of the privacy practices is extensive. It's not native to American thinking in many ways, such as the right to be forgotten. And then you have no choice, and the penalties are massive, and they're based on the company's overall financial position. So you have, on another side, data security, which is required by states at different levels, depending on your business, and especially if you're in fintech. So these are some of the controls that you'd be more robustly trying to implement as you're trying to go public or as a public company. But we're seeing it in earlier stages just because of the nature of the business and the regulations.
I'd like to briefly turn to the topic of initial coin offerings, because it's such a hot topic now. Setting aside for the moment the issue of, are the token securities or not securities, I was wondering if we could think a little bit about how these offerings, what do they say about SEC regulation and the securities laws? What do they say about the SEC and its approach to regulation? What does it say about investor protection? And some of those broader issues. Lona, would you, as a former SEC attorney, how do you view these offerings?
While I take notes, thank you.
How do I view the offerings? Well, you've sort of taken away the most important piece of whether it's a security or not. But without having that discussion, it seems like the SEC is sort of still finding its way with how to deal with initial coin offerings. The 21A report was great on the Dow, but it was such an easy situation. To say that was a security was like saying a share of IBM is a security, right? It wasn't really that big of a leap to make that determination. There's reluctance. I think there's reluctance in the staff and there's reluctance among the commissioners is to provide what I think Adam referenced, which was a broader framework around how to think about this developing market, and how do you conduct an initial coin offering? How does that work within the securities laws? And if you're going to do a private placement, how would you consider that? The SEC said they want you to come in and talk to them, and I think I know clients have done that, and many more will continue to do that. But I hope, and maybe it's too early for me to pass judgment, but I hope all of those discussions produces something that is posted somewhere that we can benefit from, that everyone else can benefit from the discussions and the analysis that's going on, because I know they're thinking about it, right? They've got task force and groups and thinking about this, but sharing that through guidance would be really helpful, because I think you see it all the time. I don't know if you saw the most recent S1 filing for, I think it's called the Praetorian Group, which is the first S1 filing for an ICO. Just open it up and read it this afternoon. It's they would have benefited from just an ounce more of guidance, right? They may have not filed that S1, but so the lack of guidance results in things like that, and more bad situations like the Dow or the Praetorian Group or things like that results in Congress getting worried and people worried about the mom and pop investors, or as Chairman Clayton calls them, Mr. and Mrs. 401k. So we more and more guidance is needed to provide some framework around it and how to think about this, because there's no you're not going to shut the door on this, right? This is something that's going to develop. It's going to have bumps along the way, and eventually there will be a process and a mechanism around initial coin offerings. But more a louder voice from the SEC earlier would be better.
Yeah. Is there a particular?
Any thoughts? I'm sure you could go. Well, how about keep it to 2 minutes or so? Any thoughts?
Well, even knowing what a regulator is still thinking about would be nice. I had a panel up at our firm up in San Francisco, and we had some former SEC people and some current SEC people, and unfortunately, they just weren't comfortable talking about, what the struggles are, what are some of the issues, and even that would be useful, right? Right now, we have guidance, not really guidance in a formal way, but because of the Munchie order, we know that the SEC considers most of the token sales, even if they're not for equity, that because of the way that they're promoted, because of the way that they're marketed, to be investment contracts, forward contracts for the tokens that are marketed in such a way that they end up constituting a security. Okay, great. Now we can file a Reg D for those and make sure that in the United States we keep it to accredited investors and deal with things that way. That's fine. But the difficulty is that these blockchain assets at some point are meant to operate either as a payment mechanism or as a smart contract that interoperates with a software platform, highly distributed software platform. And the problem is that and a stock certificate don't really work together. And also, at some point, they don't need to be. Some of the reasoning came from, and we were talking about it last night. By the way, what's funny is you'll have securities lawyers and corporate lawyers, and none of us realized what we didn't know back in 2012. And now we're all going back to, frankly, class to try and go, well, what is a security, and what is the reasoning, and what is this most like? And frankly, it's what I love about the law, is actually having these kinds of questions. I've been lucky enough to live in interesting times, ever since I started practicing in '94, and going with this internet, how does this work legally? So the idea here is, even if the initial sale of the investment contract is a security, when do the tokens become tokens again? And it's an interesting question, and some of the closest cases that are close to it is, one of the great ways of defrauding people used to be what were called warehouse receipts, warehouse subscription receipts. And this was, somebody came to you and said, hey, listen, I've got a whole bunch of whiskey in a warehouse. You give me money. You get a certain subscription right to some of the whiskey. After it ages, it's going to be worth 10 times what it is worth now. You're only paying this much money, and you're going to make a fortune. And this was used both for true investment and for defrauding people since the 20s. It took until the late 60s before the SEC actually could convince a federal court that this is an investment contract, and therefore they could enforce the securities laws with respect to the fraud. But the point here is that even if you agree, and you should agree, that the sale of those subscription receipts are an investment contract and thereby, therefore fall under securities laws, at some point the whiskey becomes whiskey again, right? And right now I can tell you this is what we all need guidance on, and I'll bet you if I could stick enough people in a room at the SEC and other places, we'd actually come to a conclusion that we'd all agree on within, 24 hours. I really mean that sincerely. But there's no short form process for that, and it's unfortunate.
Let me ask a quick follow-up, also a question from last night. How important do you think ICOs are to the development of blockchain technology? And why, if we just got rid of ICOs tomorrow, why wouldn't it just be funded by venture capital and other more traditional forms of financing?
It's going to fundamentally change where the technology goes and impact different areas, whether it's healthcare and healthcare records and real estate transactions, because it's basically, think of it just a new database software that changes how we can do many, many, many things. IBM and a whole bunch of other people are going after supply chain management. They don't need ICOs in order to do it because they have clients that will pay them $2 billion for a 6-year project because the return on investment is going to be massive when they redo the entire supply chain management for international shipping, for instance. So how important it is, I would say it's kind of crucial. I expect that token sales, and let's not call it ICOs, but the idea of offering a payment mechanism or a smart contract that interoperates with it. Here's the analogy I used to give, is what if IBM wanted to build a new mainframe? Instead of trying to raise the capital, said, you know what, I'm going to have a special punch card, and I'm going to charge everybody. I'm going to sell 1 billion of these. I'm going to sell them for 10 cents. I'm going to take the money. I'm going to, by the way, I'm assuming this is 1960, and I'm going to raise the money through the sale of these punch cards, right? It would be a magnificent new way of really financing new mainframes in a way that would be difficult otherwise, because otherwise you're saying, this is a new Linux computer and it's going to do all these amazing things, and the investor might go, what's Linux? Well, what we have is a new system that especially if it's open source like Linux, and investors are like, well, wait a second, what are your barriers to entry? How big is this market? What's your current revenue? Because a lot of times the venture capitalists are not coming in until you have significant traction. And a lot of these ideas, like voting systems, and I think one just got implemented 2 days ago in Africa, but the sales cycle is quite difficult even after you get the technology working. And so it's not going to be terribly much like the Kickstarter campaigns you see. In a way, the idea of being able to access original participants and investors using this methodology, especially where you have highly distributed teams. I mean, a lot of these teams are not in Silicon Valley. They're, the CTOs here and the other guys here, and it's how those teams are going to continue. They're going to be highly distributed, and so having a mechanism that is also highly distributed to raise capital would be incredibly important for them and effective, ultimately. So I think the answer is the evolution of the ICO, I think, is going to be critical for deploying that technology internationally.
Just to bring it back to LA, Nick, could you tell us what sorts of companies are you particularly excited about in Los Angeles? What sorts of areas do you think are promising for investment, just from your perspective as a lawyer working with these startup companies?
Sure. Yeah, I mean, LA's comparative advantage is, obviously there's a lot of content here. So a lot of exciting digital media, content-related businesses. There's also a big, fashion presence here. So we've seen quite a lot of success in, e-commerce, consumer-facing products. Fintech is another area that a lot of people are focused on right now. Ad tech here in LA. So there's certain areas that LA, I think, has that advantage, and I think one of the reasons that Silicon Beach and the LA market has continued to grow. But I think as Adam pointed out, once this blockchain sector is becomes clearer, we're seeing a lot of people interested in the space right now. I think it's really early, but I think that in LA that could be a big industry, just if you compare how much is going on already here compared to other markets. Given the size, I think that could be another area that we're going to see a lot of.
Great. All right, we have about 15 minutes for questions from the audience. I'd like to open up now. In the back, sir.
How are you advising your token issuers? How are they managing the legal risk? Because one day the SEC might just say, you guys are all committing security violations, yet they're distributing all these tokens into the system. How are you managing, how are you counseling them, and how are they managing personally the legal risk?
Yeah, it's a good question. We try to, where we know how to comply, we comply, and where we don't know how to comply, we don't do it. I mean, it's the best way. And, there are people that have called off token sales. There's people who have said, you know what, I'm going to limit jurisdictions. That has mixed results because ultimately you may have users in other jurisdictions, including the United States, so it becomes tricky. One is not like the other as well. I have, it's kind of funny, I just had a company that, they came in, and for some reason I thought that they wanted to do a token sale. And, it took me a while just to realize, no, they're just a blockchain company, and they have blockchain assets that you have to use in order to use the platform. They don't want to have a big, pull tent event where they're trying to raise funds for this. In fact, they don't need any funds, they're fine. And so the trick there, of course, is to make sure that nobody sees what they're doing as a token sale just because they're using blockchain assets as part of the platform. There's other companies which I like seeing, which are not only embracing the idea of making sure the investors are treated as investors, but also saying, you know what, if it's going to be an investment contract and the tokens are going to have, we'd actually like to, try to create investment contracts where the tokens actually do distribute gains, but we'll need to do that by registering the tokens because really it's like a piece of equity, and so they're looking at Reg A+, they're trying to look at other avenues of ways of doing that, but the solution isn't clear yet, unfortunately. So it's, it's challenging.
I think that what I've found is that the client or potential client that comes and talks to you doesn't really have a sense of anything that Adam just described, right? They've heard about an ICO and they want to do an ICO, and someone's told them to write a white paper, so they've done that, and they put ICO and white paper together and they present it, and they say, I want to do an ICO.
Next week.
And talking to them about what's your idea, what's your business, is the best conversation you can have. And there's reputational issues for all of us here, right? We've got, there are, our firms are, to the extent we're tagged with this really bad idea or this really bad investment, that doesn't look good enough. So we have to scrutinize it as well. And if they're, and we'll give the best advice. And if they don't want to take it, I'm hoping that the next door they go is going to give the same advice, but unfortunately that may not always be the case.
Up in the front.
I wanted to ask what you think about SAFT agreements.
I think the model agreement needs a lot of work if you're going to use anything that resembles it. I mean, it's long and short of it. And of course, it's considered a security. I mean, that's clear to us after December, after the Munchie order. If anybody had any, the SEC definitely sees it that way. I would expect federal courts to actually uphold that in most of the facts and circumstances. Because it's getting sold to, if it's getting sold especially to people that are not going to be using the tokens, right? If it's being sold, within a framework of language and communication that is about the success of the platform and potential profits off of, by entering into the SAFT and so forth. But just as a model document, I think everybody sort of goes, well, we need to, make some edits and change a few things, say the least. And a lot of times it has to do with a particular approach that a company will have. To the credit, the thing is the people that developed it tried to have something that looked familiar, and there was this agreement, a simple agreement for future equity, which, frankly, when that got drafted initially, I think it was a Wilson Sonsini guy who was working with Y Combinator. Many of us were surprised investors were going to go with it, but the seed investors didn't mind at all. And all it is, really, it's a warrant, right? It's an option agreement. It says, give me money now and I'll give you stock later. And so that got adapted. But a lot of the other problem that, here I'm trying to sort of explain why we shouldn't, as much as I've said publicly different issues with the SAFT, you have to go, well, is because literally every 2 weeks we're putting in new things and taking things out of contracts that have to do with this. There's new ideas. Our clients have different ideas, and you have to go back and say, well, okay, well now what? What needs to change about this? What happens in this kind of circumstance? So even if it would have been the most amazing, incredible document, it wouldn't have been adopted by the people that did UCC 2 or something like that. The bottom line is that it would have to have been rewritten quite a bit between now and then. Does that help?
So hand and on that side.
So relating to a question that Mr. Park asked earlier on what kind of advising you do on disclosures and other things for early stage companies, I wonder how much predictive work you're doing for clients in their strategy, in their legal strategy, in their fundraising strategy, thinking ahead to subsequent rounds. So if somebody comes to you to do a seed or an A, how much you're thinking about the series B or C, and how much kind of proactive strategizing you do with them. And along the same line, when you get to B and C rounds, where do you most often find yourself saying, I wish my client would have asked me this back in the A, or I wish I would have thought to advise them on this topic back in the A?
Yeah, I would say we're always looking ahead, even beyond just the B and C, towards what's the ultimate path to liquidity here, and trying to set the company up for success as early as possible. We'll frequently have clients come to us further down the line, and there are issues, and it costs them a lot more money than if they set it up right the first time. So, to answer your question, we're always looking ahead. The way growth companies work, they're generally iterating on the documents that they've already put in place early on. The venture world has, for better or worse, kind of adopted standard practices, right? And that's enabled financings to be done in a cost-efficient manner, and to make it more predictable for all the parties involved. So you're not starting from a blank sheet of paper every time you're doing a financing. So you might be working from the MVCA forms, and then everybody kind of knows what that would look like. I don't know so much about disclosure, but certainly, thinking ahead in terms of, at what point do you want to start getting audited financials, which will be important, maybe for a later stage investor or otherwise an acquirer, making sure that your IP is, buttoned up. If your company is one where the name's important, do you have your trademark protection in place? Have you done the searches that you need to do, that a buyer is likely to do? So we're always trying to think of it in terms of if we were representing the buyer or the lead investor in a later stage financing, what are they going to be looking at? And sort of, back into, what do we need to do today to ensure that everything's in place? I mean, number one issues that come up in financings routinely is IP issues. You've got a founder who hasn't assigned their IP to the company. The company doesn't have, the IP protection they need. Maybe it's tax issues where the stock wasn't issued appropriately early on. Uncertain capitalization, which sort of goes to the issue of, the crowdfunding. If you have thousands of, stockholders, that makes people nervous. So, making sure your capitalization records are buttoned up. If there are material contracts that are important to the business, what are the provisions around those upon a change of control? When can they be terminated? Do you have, restrictions on your ability to, work with competing businesses? Do your, important partners, your important suppliers have restrictions on your business that are going to, prevent you from being able to scale? So all of those types of issues, you want to be looking at those as you go along, so that you don't run into, what could end up being a deal killer.
And
Sorry, if we tie that back to blockchain, have you ever seen an early stage token sale scare off investors in a later stage?
yes. Yeah. And it's something that people undergoing, again, I handle a different sort of category because it's usually American teams with developed technology who want to do everything by the book. But, how much that might scare off a successive round remains to be seen. But if you took a look at the token sales that were being done, I don't know, at any time really, most of the ones that you see, I would think most Silicon Valley investors, even though they might, want to invest in it, and maybe they did in the token sale itself, they could be very hesitant to invest in the company after that. Part of it is the regulatory taint that would be hard to get rid of if it was done improperly. A part of it also is just, if they raised a lot of money, to be quite frank, you can really, very few companies have teams that know how to handle $20 million all of a sudden, or 15 or 50. There are very, very few companies and very few entrepreneurial teams that can handle that influx of capital. And so suddenly you're giving a whole bunch of people that maybe they've never really have any sort of senior experience or 10 years of experience, and suddenly they have a huge amount of capital. There's a very good chance that the company's going to go in a poor direction because they just won't know how to deploy it. They'll be emphasizing the wrong things, have a hard time managing treasury, and so forth. So I could see that also being another major issue.
I think part of it is the uncertainty, right? I mean, it's not unusual for investors to accept risk. They'll often look to us to help them try to quantify that risk. And often that's why, an investment is potentially appealing. If you're willing to take the risk, there's potentially a high reward. But where you've got such uncertainty as you do right now in the regulatory environment and really not having any clear guidance, that makes it challenging for an investor to sort of try and quantify that risk and make an informed decision. So I think, once we start getting better guidance, maybe some kind of safe harbors that we can rely on, I think that'll make it much easier for investors to analyze.
Right, because that risk is huge, right? That's a put, right? You've got to buy back if a regulator comes and says you did it wrong. That's a cost that I don't think anyone's ready to bear.
Hand way in the back. One final question.
Adam, I didn't quite get where you were going when you talked about the whiskey warehouse analogy. You said it's a security, but someday it's also a whiskey. Where were you going? If it's already regulated under the securities laws, the fact that it's a tangible item or as utility separate from the securities laws, what is the significance in terms of the message you were trying to convey?
Oh, sure, sorry. Well, downstream, When the investor gets their aged whiskey and they put it into the retail market, the notion is that, you know, when you buy that whiskey at your local, I don't know, whiskey place, at your supermarket, you're no longer, nobody needs to look for a 144 exemption, right? Hopefully. That, you know, if there's a repurchase of the whiskey, or, you know, you don't have to worry about Regulation M. If there's, you know, in other words, at some point it becomes whiskey that can be treated just like that without the rubric of securities laws, be it in some, you know, having a securities lawyer take to look for exemptions or registrations or what have you. You know, when does it happen? You know, most likely it would seem that it's no longer being sold with the expectation of profit, right? Being put into the mind of the buyer that they could somehow gain a profit because this is actually an investment through the efforts of the team making the whiskey, right? What's interesting is that there's another model as well. You know, when a lot of this came up, I went, you know, boy, maybe we were doing things wrong for a lot of times, because a lot of times in the Silicon Valley, you'll do software deals, and one of your first software deals is with a major distributor. And the major distributor goes, how close are you to being done? Like, well, we're pretty close, but we could use some money, because then we could really be done, we do a better job. And the major distributor says, you know what, here's, you know, $1 million, $2 million. But I want some special rights over the distribution of the software. I want a discount that's going to be, you know, farther off MSRP and so on and so forth. But, you know, I'm a great distributor. I'll get it into Fry's. I'll get it on, you know, eBay. I'll do these distribution chains. Go, great. Take the money, and the team actually develops the software and then goes into the distribution channel. Nobody has tended to treat that I know of, as a security. And part of it is the argument that the distributor is taking activities so that the distributor, although does the distributor have an expectation of profit? You bet. It's the only reason they're a distributor. But maybe they're providing a certain amount of services and value add by distributing, figuring out how to distribute it, how to package it, that it's no longer just relying on the efforts of the development team. Likewise in movie contract deals, international distribution contract, how does that work? I have my star, you could be, you really could be. I have my star and I have a script. And I have not developed a movie yet as a producer, but I'll go to the international market and I'll say, hey, listen, can I sell you South American rights for $500,000? And I sell it, and then the team goes and develops that movie, an intellectual property, and then it goes through the distributor, right? I haven't seen cases either under federal securities laws or risk capital cases where there's been an argument that it was, in that format, those facts and circumstances, considered a security. So one way that I'm thinking that it can develop is that really the investors begin resembling distributors that are creating value adds in terms of getting the blockchain assets, smart contracts, or cryptocurrency in front of a consumer market, the same way that the guy is getting Intuit software at Fry's, right? And creating a value add such that really it becomes a distribution agreement for software, which is really what's kind of going, you know, in a way what's going on. So, at least in some cases.
Thank you. We have about 15 minutes to pick up box lunches, and I believe we bring them back and eat them in our seats. And I urge you to stay for the 12:45 talk. Dean Jennifer Milken is going to interview Brian Lee, a founder of Honest and LegalZoom and a number of other companies. And please join me in thanking Lona, Nick, and Adam for a wonderful panel.
There we go.
Thanks so much.